and welcome to another ABI podcast. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. Today I'm joined by Mark Stingley and Michelle Masoner, who are co-authors of ABI's newest publication, How Secured Are You? Mark is the global head of the Bankruptcy Restructuring and Creditors' Rights Client Service Group for Bryan Cave. He's a fellow of the American College of Bankruptcy, a past education director for ABI's Secured Credit Committee, and a member of ABI's Board of Directors. He is a frequent author and speaker on issues surrounding secured credit. Joining Mark today in our studio is Michelle Masoner, who is also a member of the Bankruptcy Restructuring and Creditors' Rights Group at Bryan Cave. She's a former law clerk for the Honorable Robert Berger of the United States Bankruptcy Court for the District of Kansas. Mark and Michelle, welcome and thanks for being with us today to discuss the new book, How Secured Are You?
Thank you.
Thank you.
This book is a product of ABI's Secured Credit Committee and is authored by several members of the committee. So Mark and Michelle, why did the committee feel that this book was important to produce? And who is the intended audience?
Well, let's talk, first of all, how it really came together. Judge Michael Fagoni, who at the time was not on the bench in Maine, was the head of the project and invited several of us on the committee to put together a book that would be under one cover, would have a complete analysis of the issues that lenders would face at various points of a bankruptcy case. And we started working about 2 years ago and have been through a number of analyses and rewrites to make sure that we got it correctly. And we think it does cover the waterfront and is a very good analysis of the topics, and they were all thoughtfully put together.
That's great. And so the purpose of the podcast is to kind of go over some of those issues. So in general, can you tell me what are some of the big issues that secured creditors really need to look out for when a debtor files bankruptcy?
Well, Amy, I think the best way to do that is just to give you what the chapters are, and I think you will see that we really do cover everything. Starting with Chapter 1, which is by Stephen Falangia with the Walls, Pizzi, O'Reilly, and Falangia firm in Newark, New Jersey. He talked about allowance and determining the amounts of the secured claim, which led into Chapter 2, which was written by Judge Mark Mullins, who also wasn't on the bench when this started. He is in the Northern District of Texas, and with the help of some of his former colleagues at Haynes and Boone in Dallas, Jerome Yates and David Staub, they talk about the value of collateral. So as you can see, it's flowing in what is the amount of the secured claim and then how you determine that value. That led to our third chapter, which is by Annette Jarvis from Dorsey and Whitney in Salt Lake City, and she has a very complete analysis of how you protect and preserve collateral. And really, it even goes beyond just a bankruptcy analysis. It goes into how you, before the bankruptcy even is filed, you take a look at how you determine what the claim is about, what issues can arise, how you can strengthen your position prior to the filing of the bankruptcy. Then Damian Schleibel, Davis Polk in New York, along with Stephen Perrano and Michelle McGreal from Davis Polk, added a chapter on adequate protection, went through a number of the issues with regards to adequate protection, leading to the Chapter 5, again by Judge Mullins and the Haynes and Boone lawyers, David Staub and Jerome Yates, talking about the sale and use and lease of collateral. Really a complete chapter, I think one will see, regarding what are the issues regarding selling collateral. And I'll get into that more in depth here in a few minutes. Chapter 6 was how you determine carve-outs, surcharge, and priming liens. That, again, was written by Stephen Falangia of the Walsh Pizzi firm in Newark, New Jersey. Chapter 7, again by Damian Schleibel and Stephen Prana and Michelle McGreal of Davis Polk, talk about avoidance actions. And then we get into Chapter 8, which Michelle and I wrote together on how we classify and treat secured claims under Chapter 11 plans, which then led to a Chapter 9 chapter on secured claims and consumer bankruptcies, which I think was a really something that, if you look at other books regarding secured claims, there might be on business bankruptcy claims, there might be a separate book on consumer claims. We really, I think, have added something here by having both the secured claims in Chapter 11s and Chapter 13s under one cover. And so, as you can see, it's a complete analysis. 9 chapters, 284 pages of really in-depth analysis of secured claims in bankruptcy.
That's great. It definitely sounds very comprehensive. So is it aimed at a practitioner or is it aimed at a business person?
Well, I think both would be interested in it. Obviously, anybody who's lending and taking a security interest in collateral, there's definitely practice pointers, even before the bankruptcy is filed, how to prepare your loan documents and nail down your security interest before the debtor even faces any trouble. But then definitely it's a great compilation of expertise and case law for the practitioner.
And I would say it's an easy read. And it's put together where, as Michelle just alluded to, a non-bankruptcy practitioner could read it and really pick it up very quickly about what the issues are and how to solve the problems.
Well, let's drill down into some of those issues that you just walked through in the table of contents. You said there's a chapter on valuation. What are some of the biggest issues you see today as they relate to valuation secured claims?
Well, first and foremost is what's the purpose and use of the collateral going to be in the bankruptcy, and that starts your analysis. But then also what this chapter does is it actually walks you through putting on your case for establishing the value of the collateral that you want, from obtaining and qualifying experts to challenging counter experts, all the steps of putting on the evidence to establish the value of your collateral.
That's great. That's great. And then, there are several instances in the book the authors discuss the issues of secured creditors filing a proof of claim in a bankruptcy. If you are a secured creditor and you haven't had a debtor file bankruptcy before, you'd think that your natural instinct is to have the secured creditor file a proof of claim. You're submitting something to the court that says, here's my claim. Why is this an issue in courts?
Well, and by the way, Annette Jarvis covers this very well in her chapter regarding should you file or shouldn't you file a claim. In that particular chapter, let me just give you some high points that she talks about, Amy. She talks about the fact that you could be fully secured. But let's assume you're not fully secured. We get into the bifurcation issues about whether or not you will have standing if you don't file the claim, whether or not you can make an 1111B election if you don't file a claim. And then through case sites really takes us to the point of, I think most people would come to the conclusion there's no reason why sometimes you probably shouldn't file a claim. And I think answers the question from the very beginning in this chapter, from the very beginning, about should you or should you not file a claim, coming to the solution that I just told you. But it's not just file a claim, it's you should file a claim because 1, 2, 3, 4, and as I said, Annette goes into an in-depth analysis in this book about the reasons why you should file a proof of claim.
That sounds very, very helpful for especially a secured creditor who is interested, who has his first bankruptcy filed and trying to figure out what to do. And also in several also in several places in the book, the authors talk about adequate protection. Can you explain that concept and when that comes into play and why it's important in bankruptcy cases?
Sure, it's really important. It gets a whole chapter to itself in the book, but as you say, it's mentioned throughout almost every chapter because it is so pervasive throughout the code and through the bankruptcy process. But the authors of the Adequate Protection chapter is our team at Davis Polk, who did a real good job. And what adequate protection is, most practitioners know, is cash, replacement liens, perhaps it's your equity cushion. It's the benefit of your bargain. It's the value you're going to get during the bankruptcy proceeding to protect you against the decline in value of your collateral during the bankruptcy proceeding. And kind of a trade-off. If the debtor wants to retain the collateral and use it in its bankruptcy, then it needs to provide the creditor with some value in return for. And that's exactly the context that it arises in. It arises in the sale, use, or lease of collateral. If it's not being provided, it's a basis for obtaining relief from stay and getting your collateral released from the bankruptcy.
So it's a key concept to really understand if you represent secured creditors in Chapter 11 cases.
Absolutely.
Yeah. You mentioned sales. That is an important concept, and secured creditors are always very interested in asset sales in a bankruptcy. But what are some of the biggest issues that they face when a debtor looks to sell its assets?
Well, as you know, under 363B and C, our first step is to discuss, is it an ordinary course sale where you don't need court approval, or is it out of the ordinary course? And there's quite an in-depth analysis in the book of the horizontal test versus the vertical test to see if it's something that might be deemed to be an ordinary course sale. And after they get through that analysis and we move on to sales outside of the ordinary course of business, you have the business judgment test about whether or not it would satisfy the business judgment rule to go forward with a sale. Also, they cover, and you should always take a look at whether or not the sale of all the assets isn't really a sub rosa plan, and the chapter has, I think, a very good analysis of if the courts, and if there are splits, which courts will treat the sale of all the assets as a sub rosa plan. Then they get into, in the chapter, and this is very important, of course, in connection with any sale, if whether or not you can satisfy the issues, or the standards found in 363 F1 through 5. Because if you can't satisfy one of those, then the sale won't be permitted. The chapter gets into F1, which is it permitted under non-bankruptcy law. It takes a look at the secured creditor consent issues, whether or not you can get implied consent from of the creditor's actions. Then it spends many pages discussing the split in authority on 363 F3 about what is the aggregate value of all liens. Is it the economic value of the liens, or is it the actual value of the amounts that are owed? And if, of course, there is some split there between what Clear Channel said and some cases in some other jurisdictions. Then they talked about several pages worth of the bona fide dispute standards in 363 F4, and finally what constitutes a money satisfaction in 363 F5. That's really the nuts and bolts of what you have to do to get a sale approved, is to make it comply with one of those. Then they go into, in the book, and as always one of the issues, what are the typical timelines and what are the typical type of procedures that are looked at in connection with an auction, how you determine your stalking horse. There's a checklist of what a stalking horse would want to have included in an asset purchase agreement. There's also a checklist on what you normally would ask from other creditors to become a qualifying bidder. And then they spend a good deal of time in the book also on how you determine the highest and best bidder, because as you might, and we all know, sometimes the highest bid isn't the best bid. There are cases where the second highest bid, you can have immediate cash satisfaction because the monies are escrowed somewhere. There's a line of credit that can be drawn upon immediately, so a lower bid could be a better bid if it can be closed in faster order. Then there's a credit bidding section. They talk about the Radlax case, indicating that you can't, under 1129B, take away credit bidding rights that had been permitted in several other cases before Radlax, like the Philadelphia newspapers case, and also the issues regarding, can you limit credit bidding, like it happened in the Fisker Auto and the freelance holding publishing cases. So as you can see, really this particular chapter of the book touches on all the issues that come up and really all the issues that I think need to be considered.
Yeah, I really like this chapter of the book. I mean, the book itself is very comprehensive and provides a lot of practical advice, but I remember my first big assignment when I first started practicing law was I had to we represented a bidder in an asset sale. And of course, I knew nothing about asset sales. I knew nothing about credit bidding. I knew nothing about, and this type of book would have been very helpful to me if I had it. So, as opposed to just going and kind of looking up general information. I mean, this book is written by experts in the industry on this. And so, it just hit me as something that would have really been helpful. So I'm glad you all touched on asset sales in the book. The book also addresses, you mentioned avoidance powers in bankruptcy, and there's a nice chapter devoted to that. So what are some of the issues that secured creditors face when an avoidance action comes up, or the threat of an avoidance action?
Right, and they want to try to avoid the avoidance action.
Right.
The Davis folks of the team of Scheibel, Pirano, and McGreal did that chapter, and they did a good job. They lay out all the different contexts avoidance action can be brought, whether it's the trustees' hypothetical statuses, a statutory lien, whether it's a preference or fraudulent conveyance. They walk you through the elements of all those different types of avoidance actions, and getting a little in depth into the fraudulent transfers, challenges that lenders and their attorneys come across when the loan has issues prior to bankruptcy, and you enter into a forbearance period trying to ward off a bankruptcy. You might take additional collateral, and the authors take a look at how in bankruptcy those have been challenged as fraudulent conveyances because the loan's already been advanced. So what's the consideration for taking additional liens or an additional collateral? And they walk you through the steps of litigating those avoidance actions, the procedural issues, standing issues, defenses that the practitioner is going to encounter, much like you talked about having it being helpful for navigating your way through a 363 sale. This chapter will help the practitioner navigate through any avoidance action.
So another great topic for secure creditors to be aware of, at least as they're navigating the world of bankruptcy. And then the last two chapters of the book you both authored, so I'm sure you're intimately familiar with. The first of the last chapter addresses the issues that arise with secured creditors during plan confirmation. Can you discuss briefly some of those issues?
Sure, I'm going to take that one on, and we spend a great deal of time in our chapter talking about the different reasons for separate classification, noting that courts have always required a good business reason, a reasonable or rational justification, so to speak, or a legitimate business or economic justification to divide classes. Because as you probably or I think everyone would be aware, oftentimes we're trying to find reasons to separate creditors, maybe to get an accepting class. But we go into separate classification issues, trying to separate them based upon a deficiency claim versus an unsecured claim. We talk about separate classifications where the monies are guaranteed by a third party or secured by non-estate collateral. Again, another one is separate classifications that might be subject to litigation or set off because those are different types of claims than might be found in just your normal vendor claim. Also, we talk in the particular chapter about trying to separate essential trade creditors into a different type of into a different class. Then we do go into the fair and equitable test under 1129B. We also talk about in the chapter what's the proper rate, interest rate. We spend a great deal of time on the till rate analysis and talk about the three approaches that were in till, the efficient market rate of interest, which, by the way, the majority, along with Judge Justice Thomas, ultimately approved. We talk about the chorus loan approach, which was talked about, and then the contract rate approach, which was discussed in the dissent by Justice Scalia, and analyze exactly, what can you do, and then there is discussions regarding the famous footnote about, well, maybe you can use these in Chapter 11s too. So interest rates take up a lot. So we have classification and how you and what interest rate you can apply on a payout. We spend many pages in this chapter trying to explain 1111B and when not you could use it. And then we have a separate section on what happens if the classification's is deemed to be improper. You can possibly lose your ability to have an accepting class if you've misclassified. So we do get into that too. So the point of the Chapter 11 chapter, which we entitled Classifications under Chapter 11, is to really go in and talk about what does your plan, what should your plan contain, and then take it from there through the different parts we've just discussed, Amy.
And that's very helpful for a practitioner to know all that. Well, so Michelle, the last chapter of the book is relates to consumer cases, and as Mark mentioned, this was a add-on to the book that's unique, and I think it's I agree that I think it's a great thing to have in a secured credit book because there are issues that come up for secured creditors in consumer cases, and one issue that you discuss in the book that's been a hot topic is lien stripping. And Michelle, can you lay out the issue for us regarding some of the lien stripping issues in consumer cases?
Sure. Yeah. Lien stripping basically takes away the collateral for the secured creditor, and it's been an issue in consumer cases, especially recently with the Supreme Court taking on Chapter 7 lien stripping. It's important to the junior mortgage market mostly. A lot of the lien stripping cases deal with those second or junior mortgages, and whether they have any value or not, or whether they actually are secured claims or not. As the Nobleman case famously set the standard that if it's secured by even $1, then it's secured. Since then, there's been a lot of efforts by Consumer Debtor Counsel to remove those liens, make it a little bit easier for their debtors when they come out of bankruptcy if they don't have those junior liens on their collateral. And the Supreme Court found that the junior mortgages cannot be stripped off in a Chapter 7. It's still a little bit questionable in a Chapter 20, which of course is the filing of a Chapter 7 where you come back, you come through with the lien still intact, it rides through, and then you want to try to deal with it as a claim in Chapter 13. Again, that was Nobleman. If there's $1 of value secured, then you cannot strip it. But if you are so underwater on your first, can you strip off that second lien that does not really attach to any value in the property? And after Nobleman, it's been common practice in Chapter 13 that you can. So the nuance in Chapter 20 is that you don't get the discharge in a Chapter 13 that immediately follows a Chapter 7. And so there's mixed views on whether the effect of the debtor not being able to discharge makes that a lien, junior lien, something that you can strip off, or if the debtor is going to emerge from bankruptcy with that lien still there. And obviously you have to make a decision about keeping the property and paying both liens or however many liens are on it, or maybe it's the time to make the decision to surrender it.
So that's very helpful. You do lay that the last chapter of the book lays those issues out in pretty clear format for practitioners and also, secured lenders that work in consumer cases. I know there's so many. This book is so detailed, and there's so many more things we could talk about. But is there anything I missed that you want to hit on that is important to let our listeners know that's in the book?
Well, you didn't miss it, but I did want to give a shout out to the authors. There's 8 authors. They put a lot of time and effort into it and really produced a great product. So really happy to have worked with these individuals. It was truly an honor, and their work product is really outstanding.
Well, it's a great book that you all should be proud of. And thank you so much for Michelle and Mark for joining us today and for all your hard work on the book. And we appreciate you having you in the studio. For those of you who are listening, if you're interested in purchasing How Secured Are You, you can do so at ABI's bookstore at abi.org. So thanks to everyone for listening. Until next time, this is Amy Quackenboss wishing you well.